she's now claiming that the lender was not completely paid off, correct?
That's correct. Yep.
Yeah. So the problem is it really is. I'm not trying to like be deflective, but when the title company signs off and institutes an insurance policy saying, yes, we are insuring this transaction, then that is their challenge to then go work with the previous lender, et cetera, et cetera. That policy is in place to protect against this very thing. I mean, if we were to change this kind of metaphor to cars, automobiles, it's kind of like I have an insurance policy on my car and I get in a wreck and I now need to have the insurance company pay out on a claim there, and then they're claiming, oh, well, we didn't get certain paperwork, even though we gave you an insurance policy. So, you're just going to have to wait and see how disconnected that is. It violates the very principle of an insurance policy. And
so Westcor is the underwriter for the previous title policy that's in question, but they're also the underwriter for what we're trying to do. And so the seller has filed our seller, transaction 2 seller, has filed a claim with Westcor, but Westcor is not going to clear it until they have solid proof that all of this happened, which no one can do because no one kept records properly.
okay, so here's the pragmatic step, Stacy.
Okay.
You know who they're all fearful of? The insurance commission
Of course.
of the state of Utah. And I think I would go back with a not a agitated tone, but a very direct tone and be like, listen, I'm sorry that you guys didn't do your job well. That's not our issue, and you're now making it our issue. If you'd like us to get the insurance commission involved and explain why you issued a title policy and now are not allowing somebody to move forward because you didn't do your job, we can go have that discussion all day long.
Yeah.
I mean, unfortunately, sometimes we have to use a little bit of stick and not just carrot. And it's time to unveil a little bit of the stick and be like, I'm sorry, I'm not going to play your games, right? Because you didn't do your job back on transaction 1.
Yeah.
If you want to have the insurance commission have you crack open the files and go through it with a fine-tooth comb so we can get this done, happy to instigate that immediately if you'd like.
Okay. Yep.
Okay.
Yeah, we'll just use bigger words and stronger, like.
All right.
Yeah, my poor buyer's having a heart attack. So
that's a good one. And I love stories like this because it's what we deal with. We don't deal with that particular issue all the time, but I mean, it fundamentally raises the issue. Why in the hell do we have insurance policies if the insurer's then going to claim, well, wait a minute, we have, a problem with some paperwork, which is really our fault.
Yeah.
Meaning the insurance company.
Totally, yeah.
And you just need to wait and be patient while we try and get our stuff sorted out.
Yep. Yep. So, exactly. Well, thank you. I appreciate it.
Absolutely. Okay, Dan, go ahead.
Yeah, just have a stubborn listing that's taken a long time to get under contract. Part of that is because we mispriced it initially based on there's some odors and whatever else going on, right? And so it's just they've been stubborn in lowering price to respond to the market. We've had lots of showings. So I put together a pretty good email, convincing enough to, show that there's been a little bit of a tail on pricing in this area. It's in Spanish Fork. And, with, rapid stats and other things, we were able to show the prices easing a little bit and we need to get ahead of the curve a little bit. And we did that and went under contract for a few $1,000 less than what we had lowered the price to. So I think it was a win for these guys and a win for stats to help sellers wrap their head around a rapidly moving market.
Yeah. You know what? I hope you guys understand. That's why I spend time showing stats, not just for trivial pursuit. There's no value in that, but where you can apply them in specific situations to give people not only logical backup, but a lot of times the visual is where the real value of knowing a few of the key stats comes into play. You don't have to be immersed and be like some actuarial science geek. I'm not even to that level, but if you were at sales meeting this past go round, I just wanted to share this with you because it's one of the things we covered. If you go into Rapid Stats, right, and if you go down to my charts, now you won't have anything, so I'm going to quickly show you how easy this is to do. I showed this to Dan the other day. I have one median sold price from January of 2000. So I'm just going to create it from scratch. You come to this interface. Can y'all see this okay? I'll take your silence as a yes. Okay, so residential listing, you select the status. We're looking for closed properties. What field are we looking at? We always use median, not average, right? And you're like, oh, not enough data. Well, you have to create the chart first before you can make it any more detailed. So I come over here and apply the timeline, and I simply say, instead of go back 2 years, let's go back 6 years. Oops, 72 months, right? And then refresh the chart. How hard was that, right? My point in doing this is to Dan's situation. We get this a lot with sellers, right? They wax optimistic. This is May of 2019, okay? And we ride all the way up to the high point of the COVID, craziness. And then the market said that was insane. Let's correct. And it overcorrected a little bit down, which is typically the case. Then we settled back up. What is really the new threshold? So look at this. This is June of 2023. And pretty much since June of 2023, I mean, we've fluctuated about $5,000 in 2 years, right? That is such a powerful visual to show a seller and say, listen, I could talk till I'm blue in the face, telling you why you need to price correctly in this market. But if you can see all of these months where, I mean, there's a little bit of ebb and flow in the seasonality throughout the year, but I mean, we're stuck. We're stuck at 500, somewhere between 500 and 510. We're not moving, right? And turn that around and just ask them. So if you were in my shoes advising somebody else as a client, what would you tell them they need to do with their pricing, right? Make them ask the question, right? And it becomes somewhat obvious to them what the proper course is. Is there always going to be 5% that's belligerent and will still say, yeah, but my house is worth $100,000 more? Yeah, but at least you did your job and gave them the visual, okay? All right, so today we have covered a lot already in this year, and I appreciate you guys getting on and getting better at your craft. What I wanted to cover today was key addenda and keys to writing addenda. And I'm just going to rattle off. Oh, you know what I need to do? I need to set my timer to make sure we stay on track. We have 43 minutes. Here we go. 43, start. Okay. So in 43 minutes, want to talk about just a couple of the quick general concepts. The Real Estate Licensing Practices Act that governs us writing addenda. And then here's what I hope to get through. The resolution of due diligence addendum, the closing cost addendum, the reinstatement addendum, the subject of the sale of the buyer's residence, and the time clause addendum. I have 3 more if we can get through those 5, but I'm not super optimistic we'll get through all 5. So first concept is in writing contracts. This is a trick question. Give me a brief answer about the most effective way to write an addendum. I gave you the answer in my question.
Use their writing. Use the form.
Well, yes, that is a good one too, Bill. The joke is brevity. Brevity almost always wins the day in contracts. Having done this for nearly 2 decades, usually when agents get in trouble, a lot of times unintentionally, is when they give too much information. They give too much excuses, too much rationale in their addenda. The most powerful contract language is when you keep it certainly with enough detail, but keeping it as brief as possible. If you weave in like your feelings about it, the reasons behind it, you just open the door for people to argue or disagree with your feelings, your rationale, your justification. You know, think of those crime dramas, you know, where you're in a courtroom and they're asking questions and it's just the facts, ma'am, just the facts, right? That should like go through your head when you're writing an addendum. And to Bill's point, actually, I'm going to bring this up on screen. Let's see. Maybe. All right. Dan, I'm going to pick on you.
Let's go.
This is from the, okay, just to remember this, you guys, there's two things. There's the Real Estate License Practices Act, which is the actual law. And then there is the DRE, the Division of Real Estate, which is created by that law. And part of that is to allow them to create rules to enforce the law. So when it comes to writing or filling out addenda, I'm going to make this easier for you, Dan.
Thank you in advance.
Yeah, here we go. Here's my highlighted version. Go ahead and just start reading at the yellow or below the yellow.
Number 1.
Yep.
Except as provided in subsection 2, a real estate licensee may fill out only those legal forms approved by the commission and the attorney general in those forms provided by statute. Okay,
so stop there. Very clear, very explicit language. And I keep highlighting the words in case you don't see a pattern there. Fill out, not create, not be, as we like to call it, a realtor at law. You're not an attorney. You're like this 1,000th of a subset of an attorney, and it's really restricted to you may fill out the forms. Now, here's the argument you always get. Well, they created a blank addendum, so clearly we were able to write some stuff. Okay, let's wipe out the blank addendum for just 2 seconds for sake of argument. Everything else is pretty much fill in the blank with what was intended to be in the blank. That is clearly the intention from the DRE and the Real Estate License Practices Act. So if you understand that is the starting point, then it should govern you as well when we get to a blank addendum and start filling in the blank addendum. I've got a whole file folder here in my office of absolutely horrible blank addendums that were filled out. Some of them 3 pages long, typed 3 pages long. And, you know, it's hilarious because the realtors at law write terms and they steal little terms from like attorney speak and weave it in there to make it sound like they're authoritative, and all they're doing is making themselves really, really jacked up as far as problems they're creating. Okay, go ahead, Dan. Section 2.
Section 2. A principal broker may fill out any documents associated with the closing of a real estate transaction. A branch broker or associate broker, may fill out any documents associated with the closing of a real estate transaction if designated to fill out those documents by Matt Barton, with the branch broker or associate broker is affiliated.
And then item B.
And may only operate at the direction of Matt.
And then B, which is in the same token, right? A real estate licensee, just like a branch broker, may fill out a real estate form prepared by who? Legal counsel. Now, it can be legal counsel for the buyer, the seller, the lessor, or the lessee. And then item C, just to speed this up, is also anything prepared by our legal counsel. So, for instance, recently, it just bugs me to no end. For 4 years, I've been chasing getting a mobile home purchase agreement, right? And the DRE just gave us the Heisman pose, you know, the stiff arm. And, you know, we actually had Dan McDonald, an attorney here in Utah County, finally do a mobile home purchase agreement. We got that all finalized and put up. And what did they just announce?
Mobile home purchase agreement.
Yeah, they're going to come out with a mobile home purchase agreement. I'm like, mother of pearl. Anyway, but I think this is important for all of us to understand, right? I think it's not only important for us to understand if we're the ones writing it, but equally, if you were to get, Stacy, if you were to get a blank addendum with all kinds of legal speak in there or quasi-legal speak, I'm telling you, as an agent, you should be asking the question of the other side. I'm sorry, did an attorney write this?
Yeah.
Or did you just ad lib?
Yeah.
Right? Because even if they wrote it, our fiduciary of reasonable care is to point out to our side, hey, it looks like this agent wrote this, and I can't vouch for the legal validity of it. And frankly, we're only supposed to fill out forms. So if he's acting like an attorney, maybe we should question that addendum, right? That is it's not just a nice thing for you to do, it's actually your obligation. So that's why I wanted to spend some time on this and go through that. Make sense? Parker, if you look any more excited, I swear I'm going to have to turn off your video.
Dude, sorry, I just got home from working out, so I apologize.
Oh, look at
That
you.
was not like a Tommy Boy moment. That actually was happening, so I apologize.
Nice. Okay, so let's jump into it. I'm going to jump now to those various addenda that I was talking about. So I now need to bring up my. All right, here we go. This is one of the most common. I'm going to zoom in. This is the resolution of due diligence. And just as a general practice, you guys, I think it's a good idea for you to always scroll down to the bottom and make sure you're using the latest version. And once you start getting in the habit of this, or if the other side's sending it to you, because I've many times got outdated forms from people. And it's like, where are you pulling this from? Oh, I had a copy in a PDF on my drive from, 2009. You want to make sure you're using the latest version. So always look to the bottom, make sure it corresponds. You can go to the MLS and find the form and see the date, and you'll know that you have the latest one. Okay, so the resolution of due diligence. What's the general purpose of this form? Anybody, fire off.
To let the seller know that you guys have done all your due diligence and you won't ask for anything else and you're going to move forward.
Okay, so that is a component of it. But remember, part of it is, wait a minute, I did find some things I don't like. So let's stop there for a second. The very nature of the REPC, it highlights it right here, right? Section 10.2 of the REPC says the buyer is making their offer on the property in its as-is condition. But they do have due diligence in section 8.1 that says if they see something they don't like, they can attempt to negotiate with the seller to keep the deal on track, to keep things going. So that is the purpose of this deal. Even though I put my offer in as the buyer, knowing I'm buying it as is, I clearly couldn't even, look under the covers, so to speak, and see the disposition of the house. Now that I've done that, we found some problems. It could be termites, it could be a roofing issue, it could be a plumbing issue, it could be an electrical issue. So I'm not here to debate what those things can or can't be, but there's basically the UAR kind of took that scenario and said, what are the three main ways that we handle that, right? So I want to go through those quickly. Closing costs. Seems to me that's probably the easiest way to go, right? If you have not already negotiated the seller paying closing costs in your offer before you do your due diligence, what are closing costs? What's the calculation you use, Dan, when your buyer says, well, how much should I be planning on for closing costs? Is there a formula you follow?
Yeah, it's usually 2 to 3% of the offer price.
Yeah, and it kind of depends on the price, right? Because the higher we get in the purchase price, the percentage goes down because there's some costs that don't scale with the purchase price. As a general rule, I would say tell your buyers for your middle of the road, median sales price homes, 2 to 2.5%. And you'll probably come in a little less than that, which makes you look great. But let's just go with 2% for easy math. If it's $500,000 purchase price and 2%, that means there's basically $10,000 worth of closing costs available. And you can pretty quickly spitball a number and know how much you could negotiate to address a plumbing issue, electrical issue, a roofing issue, etc. Okay? Why do we recommend this one, closing costs, versus repairs to be made by the seller? What's the advantage? And there is.
The verbiage, I love the verbiage in closing cost because
Okay.
it covers so much,
Right.
right? One of the other issues too is on the repairs to be made by the seller. I'm always worried because it says all repairs shall be performed in a work-like manner with materials of quality, appearance comparable, but it doesn't talk about like who's going to be doing that work. It could just be like anybody. And one of the other things too is it can interfere with underwriting and slow up the process for the potential buyer.
Parker, all great points. Here's the thing. I'm going to give you my version of it. You guys can spin it however you want. And you're right. It doesn't say necessarily that they must be licensed, right? If you choose option number 3, repairs to be made by the seller, what does it say? Seller or buyer agree, the seller will be responsible for the completion of the repairs by settlement deadline, unless otherwise agreed to in writing. Seller shall, through contractors, notice it didn't say licensed contractors, complete the repairs to comply with applicable law, including governmental permit, inspection, and approval requirements. All repairs must be performed in a workmanlike manner. Ooh, I love vague terms like that. Who defines what workmanlike is? With materials of quality and appearance comparable to, that is just riddled with grayness. And anytime you have grayness and you have two people on opposite ends of the spectrum, you're going to have debate and argument and possible issues. So for all of those reasons, Parker, I don't like this one, right? What I tend to tell a buyer is, listen, if it's going to be done, wouldn't you want to use your roofing guy, your electrician, your plumber who you know and trust and have worked with before, versus, I don't know who the seller is going to choose. Is he going to choose his cousin who's not even licensed, but he's quote unquote a contractor, and we might run into issues later? I know that's a little bit extreme, but I hope that drives home the point. I think it's always better if you can put, and I get it, there's extraneous deals where, so for instance, if there's a roofing issue, the underwriter may not sign off on funding the house until the roofing's done. If that's the case, well then go ahead and check section 3, but addend it and say with a contractor mutually approved by both buyer and seller. Right? Can we do that? Yeah, you can. Okay. Purchase price reduction, you know, for some people who are flush with cash, this may be an option because, you know, they're like, great, we'll just take it off the 30-year mortgage. Most people, unless I deal with the weird clients out there, most of them aren't flush with cash, and they'd rather take those expenses and roll it into a 30-year mortgage rather than getting the few dollars a month it's going to save by reducing the purchase price. Right. So I would just say my preference for most of my clients would be, let's see if we can negotiate closing costs. That's dollar for dollar cash. We end up having the ability to hire our own contractors to do the work, and we're satisfied with it. And it's just cleaner. It's easier. There's no follow-up inspections, you know. Anyway. Okay.
Well, the other great part about that too, Matt, is, you know, let's say you ask 30,000, but you only need 20,000 in repairs. Well, now you have 10,000 that you can use to buy down the interest rate. All of a sudden, the home becomes significantly more affordable than what it was at the purchase price. So, you know, there's a lot of creative things you can do with Section 1 that I
just highlighted what Parker's talking about in reddish pink. Any unused portion of the seller's contribution may, at the buyer's option, be used to reduce the purchase price. So if you only use 9,000 of the 10,000, you're still going to get the full effect. You get to reduce your purchase price by $1,000. So super, super helpful. Now,
can you quickly review prepaids? Because I have a lot of people ask me, well, what are prepaids? What do prepaids cover?
That's not in here. Well, it is right there. Prepaids. Yeah. What are typical prepaids? Dan, you used to be a lender. What's a typical prepaid?
Prepaids. Prepaids are like taxes or HOA dues, stuff like that.
Yeah, the problem, Parker, is then we get the people who are creative and they're like, well, we're going to prepay our insurance.
Yes.
Unless that's a requirement of the lender, or if you exceed the requirements of the lender, I think people could balk on that. So I would say as a general rule, like Dan said, taxes, escrow reserves, you know, anything in that category. But if you get off in the creative field, you're going to get somebody to argue that. Okay. All right. Going to move along. Section 3 is important for us to remember, right? Buyer's remedies for unfinished repairs. So if you chose option number 3 and the repairs didn't get done by the deadline, what are your options? Well, buyer may alternatively elect one of the following remedies, right? 3.1a or 3.1b. If 3.1a or 3.1b is not checked, then the escrow is the sole remedy. So if you did not check box A or box B, then all you can do is hold it in escrow, right, from the proceeds of the transaction. So what is option A? Buyer may cancel. This is a big deal. If your seller signs up to do repairs and they just like, well, I got really busy and I wanted to get it done and I'll get it done, but we need to close today. You need to proceed with caution because the buyer may just turn around and say, you know what? I checked option A here and you didn't get it done, so I'm canceling the transaction. And, oh, by the way, seller agrees to pay the liquidated damages, right, which is earnest money, an equal amount of earnest money. So important to know the details of the contract, but also if you're representing the buyer, don't just leave this blank because I see that all the time. You fill out all of this, 1, 2, or 3, but you forget items A or B, right? Which means your only remedy is to escrow funds. Make sense? Option B, you may complete the purchase of the property, then pursue other remedies. In other words, I can sue you for not doing your job in the contract. And that's not going to be terribly pleasant either. Okay? Any questions on the resolution of due diligence addendum? Wow, look at that. All right, let's move on. This one's super easy.
Sorry,
and
Matt.
yet,
I got one last question. Section
ahead.
4, you have to talk about section 4 in there.
All right.
Section 4A,
Upon acceptance of this
I should say.
addendum, buyers' objections to the due diligence shall be deemed resolved. So thank you, Parker. That is a key point. So the concept here is we're sending this over to the seller. I can't, was it Donna or Stacy or somebody said, you're basically saying in section 4, we've done our due diligence and either we didn't check anything above or we did check something and here's how we're going to address it. But let's all be on the same page. Once we're done signing this addendum, you don't get to come back and claim new due diligence items. Why? Because if you're the buyer saying your objections to the due diligence shall be deemed resolved and the due diligence condition is waived. Wait a minute. Unless checked below. So if you want to basically have the ability to re-inspect the things that they allegedly were going to repair, then you better check 4A. You better check 4A. And repetition is the mother of learning, so I'll say it again, you better check 4A. All right. Moving on, closing costs. Super important, and yet what do we still see all the time in the office? We get agents who take a blank addendum and say seller to contribute $4,000, $5,000 to closing costs. Why? I don't know, because they're lazy, because it looks simpler, but they are definitely not looking out for the interests of their client. Why? Section 1, we're going to read this verbatim really quickly. Seller agrees to contribute a settlement the amount of X to be applied to, at the buyer's discretion toward any and all of the following. A, permanent reduction or temporary reduction in the mortgage loan interest rate. B, mortgage financing costs. C, closing costs. D, prepaids and escrows, Parker. And then again, much like the other one, any unused portion of the seller's contribution may, at the buyer's option, be used to reduce the purchase price. Is any of that language defined or anything when you take a blank addendum and say the seller will pay the buyer $5,000 in the buyer's closing costs? What happens if they get looking at it? Oh, this never happens, right? Never happens. The seller gets looking at it. Well, wait a minute. They're paying HOA fees, they're paying this, that, and the other. I was just paying their closing costs. I'm beating a dead horse here, but it is great when an attorney, in this case, the UAR attorneys, actually wrote definitions of what closing costs are. That way there is a meeting of the minds. It can't or shouldn't be, or it won't successfully be argued because they put their name to it and said they agreed to items A through D. Okay? So please, when you're in the rush and you know closing costs need to be paid on behalf of your buyers, please, please, please use the closing cost addendum. Don't use a blank addendum. It's weak. It doesn't, it opens the door for debates and arguments and possibly derailing a transaction. Okay? That one, super easy. Should be a no-brainer. All right. This is the one we've been getting a lot of lately. Which is the subject to the sale of the buyer's property addendum. We all know in the REPC, Section 2, it says, is any part of this going to be financed by something that the buyer owns and has to sell? If the answer is yes, then you must not fill this out after the fact. It must be part of your offer. That's what it says in Section 2. Without that, you have an incomplete offer, just in case you weren't paying attention. So if they have to sell something, you have to have this as part of your offer. I get this from agents all the time. Well, we don't want to make our offer weak, so we just don't want to tell them. I'm like, oh, so you want to participate in something fraudulent? Is that what I'm hearing? Well, no, it just weakens their offer, but it's also fraud. So don't do that. You're putting your transaction at risk and your license at risk. So there's that. Okay. So what is the basic premise of this? Dee, have you ever used this, the subject to the sale of the buyer's property addendum?
Yes, I have.
Good or bad? You like it, hate it, love it?
I like it. It's very clear, clean. I've either listed already or I will quickly list, communicate with them throughout. I try to stay in communication with the other agent, let them know how many showings we've got going, just to help keep communication all the way through in case I need extension or something else down the road, but I like it. Yes.
Okay, so Dee, you and anybody else, do you feel it does weaken your offer?
I've never thought of that, so no.
Okay, Melissa, what's your thought?
I think yes, it can if you're up against multiple offers or I mean there is that possibility because there are sellers who do not want to wait, you know, and if they have offer B that's just a quick close, they could do it, but you still have to be honest and hopefully you're communicating with the agent and there can be other ways you can strengthen it despite the that addendum, I feel.
For sure. Yeah, you can, that is such a great point, right? There's always, this is like chess. I mean, there's so many pieces you can move. The problem is a lot of agents think checkers, right? There's only one move. I put this back up on screen, right? Yes, if we were here, yeah, it's kind of tough to do a subject to sell, right? But we're here for the past 2 years, right? And so, you know what environment you're in. When you look at a property that is been on the market for 80 days, 90 days, they're probably going to be thrilled to get an offer, even if it's subject to sell. If it's 2 days in and they're having crazy showings, it's going to be a little tougher. But I like your approach. It's like, hey, listen, if we do our job well, and there's several things we can do here, right? We say, listen, here's an appraisal on our property, or here's a CMA on our property. It is listed. We've had X showings, or we just got an offer on it. Anything like that helps the seller that you're trying to entice to accept this. The problem is a lot of times we just, well, I'm just going to send over the offer. Either it's too much work and I'm lazy, or I don't have to do that. You know, the mentality sometimes kills me, right? Would you like to get paid? Would you like your client to get the house and get, their home sold as well? You're going to get 2 transactions out of this. I mean, let's connect the dots here. So there are successful ways to do it. And to your point, Melissa, we could go to section 8.3, right? and say, hey, once we pass certain deadlines, a portion of our earnest money or all of our earnest money comes non-refundable. We're committed. We are going to get our house sold, right? So there's all kinds of things that you can do to soften the blow if you have to use the subject to sell. All right. What does it say though, right? We're obviously going to declare that this is the address of the property we're concerned about. Always very helpful, especially if you have an attractive property, to send along an exhibit with this to show them a copy of the listing or whatever, or a CMA. All right, but what are the options in the contract? Section A, buyer's right to cancel before the due diligence and financing deadline, whichever is later, right? And what is the condition? If the buyer has not closed on the sale of the property, right? Not gone under contract. I've heard all variations on this. The language in here is if it's not sold, right? And you have till your latest deadline, which is your financing appraisal deadline. Now, if you're on the other side of this and you're representing the seller, you need to know this addendum just as much as the buyer's agent, because you're going to step up to your seller and be like, I think we should take this offer, right? But I also need to explain to you what some of the potentialities are if they don't get their home sold by this deadline, if they do not cancel. So we're going to want to scale back their deadline. We're going to want to make it more aggressive. We may need to counteroffer them, right? And that's showing your understanding of the contract and your willingness to help them navigate it and put some advantage to them, so it's not just so buyer friendly. But you can't do that if you don't know what it says in Section A and how to counter offer some of the effects. Make sense? Now, Section B talks about after. The buyer can cancel. They can cancel after the deadline, right? Now, this section right here basically says you can't sue them for performance, and you can't sue them for other remedies available at law. You only can come after them for the pre-agreed upon liquidated damages, which is also known as an equal amount of earnest money. So much like we were talking about just above, if this situation were to arise, and I'm a good listing agent, I'm gonna be like, hey, listen, they're only putting $5,000 up, right? We have the opportunity, with your blessing, to counteroffer them and say, you know what? We need $10,000, $12,000, $15,000 if we're going to accept the subject to sell. Now, D, I'm going to ask you a question. Is that out of the realm of possibility? You're asking me and my seller to take our house off the market, and you have an escape valve in Section 1A. Is it reasonable for us to come back at you and say, we want to play ball, but you got to put some skin in the game, more than $5,000?
I think so, yes.
I do too, right? And so as a listing agent, you have to have that level of confidence, and not only the confidence, but the ability to communicate the why. Sometimes we just fire it off, and the other side's like, well, that's bull crap. They just want more earnest money. Yeah, if I don't do my job well. But if I said that to D, hey, D, looks like you guys are solid, right? But you have to understand my seller has a little trepidation. You're telling me you're highly confident that the home sells. So you know what? It's going to sell. So help me help you. That's my Jerry Maguire. Help me help you. And you know, if what you say is correct and you're highly confident it's going to sell, this is kind of a moot point, but it's going to help my seller get over the hump in this transaction and sign off. Can your buyer come up with $10,000? Can they come up with $12,000?
Hey, Matt.
Yeah, go ahead, Mike.
How does that counteract with, or I guess you've got to make sure it's fitting well with if you do an active TC?
I'm coming to that next. So let's hold that for 2 seconds, Mike. But if we didn't have an option to keep the home on the market, time clause that Mike's referring to, if it was just this, I think this is still pretty straightforward, you guys. If you want me to take, and my seller to take my property off the market, and you got a pretty solid property, I'm probably going to come back at you, making sure there's enough earnest money so that if we are a month out or a month and a half out, and you do back out, and the only option we have is this last portion of Section B, there's got to be some equality to the transaction. There's got to be synergy for both parties. Okay? So just know where your flexibility is, okay? All right, Section 2, buyer's property listing requirement. Listen, I don't know about you. I don't know that I would send over an offer with this addendum if my property wasn't listed. That just becomes really weak. It kind of shows that's how serious you are about buying my house, and you want me to take it off the market that you don't even have yours listed yet? You see how that plays so poorly? So my recommendation is make sure you already have it listed so that you can declare that it is, and you can give them the MLS number and a copy of the listing, and better yet, show them the showing schedule that you've had, or if you just got 2 offers, you can, tell them that, okay?
So,
And then the buyers,
Matt,
yeah, go ahead.
well, in theory, that sounds great, but what if you have, you're the buyer and
Yeah.
they're going to sell their house, but they only want to move if they find a certain particular property. So if these guys aren't going to agree to terms and stuff, you don't want to put the house on the market. And yeah, so I mean, I get what you're saying, but I also get there's sometimes more pieces to the puzzle than just throw it on the market.
Well, I don't disagree with that. Of course, there's going to be like 100 different scenarios, and I have to paint with a little bit of a broad brush here. But to address your main issue there, Bill, like, listen, we're in the marketplace of ideas and transactions. There's got to be synergy. That's how deals get done. If you're not serious about selling your existing residence, I don't know that I'm too serious about telling my seller to accept your offer.
Yeah, I mean,
Right?
I guess
I mean,
my people were doing some things on their place. One of the things was getting some siding that was warranted, and it was taking longer and whatever. And so they wanted to have all those things done ahead of time. And our offer got accepted without the TC time clause because the other agent that is the owner of her own brokerage, a Remax brokerage, knew my listing history and knew that it was going to be good.
Yeah. Okay. Yeah. And those are all valid points. But as a general rule, taking out the Bill Heiser principle, if I've never done a transaction with you, I don't know anything about you, but I'm an experienced agent. My job, my fiduciary of reasonable care to my seller is like, I don't know this guy. I don't know his history. I mean, I can pull up some things, but I think the general tone for most people representing a seller is going to be like, if they're not even ready to put their home on the market, and we're relatively new on the marketplace, right, within a week or two, I would say, let me communicate back to Bill. Super excited that you're interested in our house. Hurry and get the siding done. We're fresh on the market. There's no need for us to go under contract right now, especially where your house isn't even ready to put on the market. But we would highly entertain your offer if and when you get the siding done and you get it listed or you get it under contract. Please come back to us. Is that reasonable? I mean, how are you going to argue that? I think it's reasonable and rational to look out for the interests of the seller, but stay engaged with the buyer. You never want to be like, yeah, screw you. That's not a good strategy. Okay. All right, let's jump on to, because this is where it tends to get muddy with some people. This is, if you have Section 2 of the REPC that requires the addendum we just covered, right? The seller, another thing the seller typically, frequently counters back with is the option to keep the property on the market, time clause, right? And this sounds pretty straightforward, but there are some gotchas here, and you got to know about them and you got to pay attention. Okay. So first of all, is it reasonable for a seller to say, hey, Don, I like your offer, and my seller would be willing to go under contract if you allow us to still market it and what? Accept what kind of offers?
Backup.
Thank you. Thank you, Donna. Backup offers, right? Sometimes the devil's in the details. Sometimes we just say, allow our seller to accept other offers. Now, it should be implicit understood by all that when you go under contract with contract one, it has standing, and anything else is in a sub-standing point of view. But your peers aren't always that gifted. Is that polite to say? A polite way of saying it? So make sure you use the word and accept backup offers. Just the addition of that little word backup can be helpful for an agent who's never dealt with this, right? Because they could hear accept other offers. They may think it, or their client may think, oh, they can just bump us out of first position. That is not the case here. Okay. Just had one last week, very high-end property. And the seller who we represent under contract and wants to go forward and have the option, you know, to continue marketing the property, but the buyer had the subject to the sell the buyer's residence, and the seller got another offer, and it was saved them about $35,000. And so guess what they want to do? They wanted to cancel offer number one. And we had to advise them, you can cancel an offer, you just can't cancel the consequences. And we had strongly advised you talk with a real estate attorney before doing that. And they still went forward and canceled offer number one. And offer number one's going, no can do. And it's getting very dicey. Meanwhile, they went under contract with buyer number two. So these things aren't theory always, they actually happen in reality. And sometimes our clients go contrary to our best advice. And there's a little side note there. As long as they're not doing something illegal, we have a fiduciary of obedience. Even though it feels kind of scummy sometimes, it's like, oh my gosh, if I was the agent on the other side of this and this happened to me, I would be so pissed off. That doesn't wipe out your fiduciary of obedience. Make sense?
So Matt, really quick, doesn't the time clause, the option to keep the property on the market, when you get that second offer, you have to notify buyer number one, who either releases the contingency or releases the home. So basically you force their hand to get going, right? And then, but those sellers chose to just cancel versus make the buyer cancel?
So I'm so glad you brought this up, Stacy. So if you look in section A that I have on my screen, just because we get an offer doesn't mean we have to do anything, right? That second sentence there, seller in the seller's sole discretion may notify the buyer in writing of an accepted backup offer. So Dan could bring an offer to me, and then later on, Donna brings another offer and I accept it in backup position. I may or I may not let Donna know. Okay. That is still acceptable and within the contract, but what it doesn't do is it doesn't start the clock. So, you know, the concept here is forget that scenario. I just want to let you know that that is a possibility. In most cases, if Donna brings a backup offer, then I would then notify Dan in writing, not with a text. And there actually is a form for this, you guys. It's on the MLS. I would notify Dan and his client in writing, in which case the clock starts ticking. Now, here's the question for you. Where did 72 hours come from? Is that a thing? Is that like an industry standard that I'm not aware of? Could it be 2 hours? Could it be 24 hours? Could it be 128 hours? There is no standard, but for some reason I found people saying, well, you know, they get the standard 72 hours. I'm like, I don't know where you're getting that from. Whatever the period of time is specified, right?
I think the
So
reason
section
is
B,
because I think way back in the Stone era, there was an actual form, and it was called the 72-hour kickout clause.
yeah.
I mean, way back when we had like carbon copies and yeah.
Back in the day of triplicates, Bill?
Yeah.
Yeah. Well, that hasn't been for about 25 years. So we're gonna move forward.
But now you know where it came from.
I appreciate that.
You know, Bill, I was going to say the Stone Age wasn't that long ago, and then Matt said 25 years.
Okay, so in that situation where you do accept a backup offer and you have a time frame specified here in section B, what does it say? If the seller provides written notice to the buyer, then the buyer shall have so-and-so days or hours or whatever the case may be after receipt. That's why you want a paper trail of the seller's written notice to provide written notice to the seller of the buyer's removal of the following conditions, either the due diligence, the appraisal condition, and or the financing condition, or all the above. Or all the above. Okay? What does that actually mean when you
Matt,
remove conditions?
what are your thoughts on the and or part of that?
Yeah, let's come back to that in a second, Parker. But what is it actually doing if my buyer sends the appropriate notice and says, yep, we're waiving the conditions in section B? What does that even mean? I mean, it's important for us to know, right? So what does it mean?
That they could perform without selling their house.
Or they'll be in default, in which case section 16 will come to play. But here's the thing. This is where, remember I started this off with, this is where we have a lot of muddy stuff in our transactions, right, that we get in the office. And the other side will say, well, we know, so remember, the kickoff for this was the buyer saying, I have to sell my house, right? And then we get another offer. This is where it almost always gets agitated, right? They got a better offer, $10,000 more. I guess I'm going to finish on this addendum because that was the Hunger Games. I'm dead. So if the buyer had put forward that addendum saying, yep, I have to sell my house in order to buy, I get a backup offer. It's probably a better offer. And so the seller sends over to the buyer saying, hey, you got to remove your conditions. And the buyer says, cool, I'll remove my conditions. And then what does the seller say? Well, they don't even have their home sold yet, so they can't remove their conditions. This is why I'm bringing this up. Is that even a thing? Can the seller argue that?
No.
I mean, they can't argue it. Would they be successful in arguing that is really the question.
If they put it in a separate addendum that says if they're going to stick with the offer that they have to provide reasonable evidence that they can perform, yes. Or they can cancel. Yeah.
Okay, so if you had an attorney write some good language, but no, in its default, that's not a provision that everybody agreed to. As long as I say, I'm removing my conditions, now the onus is on me to perform. So here's the crazy thing. Let's go to the extreme of why this is. So initially I said, I have to sell my house in order to buy your house. And then you send this over saying, I got a backup offer and I waive my conditions. Are there more alternatives than getting traditional financing? Can I go to a hard money lender and pick up money?
Yep.
Could you utilize the buy before you sell program from Lifetime Home
Could
Loans?
use the buy before you sell program. Could go ask Uncle Bob. There's a lot of different things. And unfortunately, the sellers kind of get their head in a mindset that they know everything about the industry and the buyer's transaction, and therefore they want to wipe out their contractual rights. And it's just not the case. It's not their prerogative. And Parker, to your question, and or frankly, I'm not 100% sure why they put two Boolean operators there when there's check boxes to the left. It either is or it isn't checked. So to me, it's redundant. It's kind of stupid. And I think the reason they did it is because they have the same deadlines. That's probably why they did it, but don't know. It doesn't matter. If all three are checked, then all three are to be removed. Okay. Now, Section 3, additional earnest money. In addition to removing the above check conditions, buyer agrees to deposit an additional earnest money deposit in the amount of, apparently the blank's missing here, buyer shall deposit additional earnest money into the same location as the earnest money within 4 calendar days of removing these conditions. So if we're a good agent and we know the scenario we just talked about, that they could potentially remove them, we could strengthen our seller's position before accepting this offer this particular addendum by in section C saying, great, if you're going to remove that condition or all of those conditions, you're also going to agree to put another $10,000 of earnest money in place so that if you don't perform your 10,000 plus 10,000, you're losing 20,000, right? It just makes it more skin in the game for the buyer and more protection for the seller, okay? Anyway, section D, very straightforward, buyer's right to not remove conditions. If buyer does not remove the conditions, then what? The REPC will automatically become canceled. I wanted to finish on that, right? The contract, in normal cases, right? We've talked about this in the past. There's an affirmative obligation to cancel the contract because it continues to live in most situations until somebody cancels. Well, guess what? This addendum has the forcing function language. If you send over to the buyer and they do not respond in time to remove their conditions, there's only one result for this contract at that point. It is canceled. It's like sending over a contingent cancellation. If you don't respond by this deadline, this is our cancellation. So there you have it. Well, we got through several of the addenda. I'm actually surprised we got that far. We will wrap up the remaining 3 next go round, but I hope this is helpful information as you go about in your day-to-day business, not just to protect yourself, but I hope you leverage this when you meet with your buyers or sellers. You don't have to go through all of these, but in the course of our conversations, we have an opportunity to make some type of a statement. One of the reasons you're lucky to be working with me, Don, or anybody, is because I've invested the time in understanding the contracts. Can I give you one example? And you could bust out any one of these just to show them the complexity of what would appear to be a very simple addendum and say, this is one of 30 addenda, right? That could possibly, I'm exaggerating, maybe it's 10, whatever, addendum that could come about in our transaction. And I hope you sleep better at night knowing you have a contract expert looking out for you, right? Don't just know it, know how to say it to your buyers and sellers so their confidence level in you goes up and you have the opportunity to secure more business. That's the goal here, is not to be just contract nerds, which you all are, congratulations, but to demonstrate your value add to your clients because you are skilled and well understanding of your contracts. Okay. Appreciate you guys. I hope you have a great week and we'll see you next time.
Thank you.
Thank you. Bye.